everyone, and welcome to the second webinar in the Young SIAC's conference. I'm Kate Apostolova, and I'm a senior associate with Freshfields and a member of the Young SIAC Executive Committee. On behalf of Young SIAC, I'd like to welcome you to today's debate by the winners of our writing competition. As you probably know, Young SIAC organizes an annual writing competition. And this year, we asked participants to submit a debate speech. The topic for the debate speech was the following motion. This House believes that contractual preconditions to arbitration should be regarded as impediments to the tribunal's jurisdiction. We received a number of submissions from close to 20 different countries, including from Singapore, China, India, Nigeria, Spain, Ukraine, France, Mexico, Panama, Australia. So a very diverse representation from all continents, from all over the world. And the results are out. Our judges, who I will introduce shortly, have chosen the best debate speech in favor of the motion and the best debate speech against the motion. Our judges chose the one submitted by In-Hyuk Hwang as the best pro-motion speech, and the speech submitted by Joan Lim Casanova as the best speech against the motion. And we are very, very happy to have the winners join us today for a debate as they orally deliver their winning submissions before the judges who selected them as the winners. So let me just briefly introduce the winners to you all in the audience. In-Hyuk Hwang is an associate in Bae Kim and Lee's International Arbitration and Litigation Group. And before joining his firm, he clerked for a state trial court judge in Colorado and for the Chief Justice of the Alabama Supreme Court. He graduated summa cum laude from Handong International Law School, where he published on the topic of whether more jurisdictions should allow appeals to the merits of an arbitral award. Joan Lim Casanova is a partner in the litigation and dispute resolution practice of Covenant Law. She has extensive experience in contentious work and dispute resolution, with emphasis on commercial litigation and arbitration. And Joan has been consistently recognized as next generation lawyer and rising star for dispute resolution. So congratulations to you both, and thank you for taking part in our debate today. We're also very excited to have two of our judges join us today. We have with us Shaneen Parikh from Serial Amarchand. Shaneen's practice focuses on arbitration, having represented clients in disputes administered by various international arbitral institutions, as well as ad hoc arbitrations. She's also a member of the SIAC Court of Arbitration. And this year, Shaneen was named one of the most highly regarded international arbitration practitioners in the Asia-Pacific region by Who is Who Legal. We also have with us Stephen Lim. Stephen is an arbitrator and barrister. He has over 80 appointments in international cases as presiding, sole, co-arbitrator, and emergency arbitrator. He's on the SIAC, the Hong Kong International Arbitration Center, ICDR, and a number of other arbitration centers panels. And he also appears as lead counsel in international arbitration. So this is our cast of characters for today's show, and I will now hand it over to the judges to proceed with the debate.
Thank you very much, Kate. Well, let's get on with the show. Congratulations to In-Hyuk and to Joan. Well done on making it so far, but you may perhaps have your greatest test yet, because you have to convince not us mere judges, but the audience that you are worthy of holding this title. So why don't we go straight into it, and we will begin with motion 4, submissions on the motion 4 by In-Hyuk.
Thank you, Mr. Lim, and thank you, Kate. If I can just take 1 second to share my screen, I prepared a visual aid. for today's presentation. Excuse me. Is the share screen function working okay? Good. Well then, let me begin. Good morning, good afternoon, and good evening, esteemed members of the panel of judges, my learned colleague, Ms. Joan Lim Casanova, in opposition of today's motion, and members of the audience. My name is In Hyuk Hwang, as introduced, and I firmly stand in proposition of today's motion, which is that this House believes that contractual preconditions to arbitration should be regarded as impediments to the tribunal's jurisdiction. And I think as a first order of business, it might be helpful if I try to provide a little bit of context to the topic of today's debate, so that everyone, all the members of the audience, can really get involved in today's discussion. What I'm going to present today is that contractual preconditions, which I will simply call conditions to arbitration, for example, that a party must first mediate their dispute before referring their dispute to arbitration, or that the parties must first wait a certain number of days, that the failure of these conditions, I will submit, is a gravely important matter, so important that it should go to the issue of the tribunal's jurisdiction. And what my learned colleague in opposition of today's motion will argue, that it is a more or less trivial matter going to something called admissibility. And I think it might be helpful to look at what admissibility exactly means in this context. I have here a quote from Professor Bourne. He writes that in the context of arbitration, admissibility generally refers to whether a claim is ripe to be heard. In other words, those who take this view, the view in opposition of today's motion, would find that whether or not the condition in a conditional arbitration agreement is satisfied, there is an underlying agreement to arbitrate. And so whether a condition has been satisfied only goes to whether the claim has been brought too early before the condition is satisfied, or whether it's come to the tribunal after it is ripe to be heard, after the condition has been satisfied. Put another way, it's about when the duty to arbitrate arises. The duty to arbitrate already kind of the agreement underlying it being there, not whether there is a contractual duty to arbitrate at all. And I will also mention up front at the beginning of my presentation that the majority of the legal world today, jurists and judges from around the globe, have taken the view that contractual preconditions really go to the issue of admissibility. Prominent jurisdictions such as Singapore, Hong Kong, England, the United States have all decided this way. And so with the remainder of my time, what I will do is first explain that the view that I will take, the view for tonight's motion, that these conditions really go to the core issue of whether there is an underlying arbitration agreement. I will submit that this is actually an intuitive case, quite an obvious one. And I will move on to explain that those who take the opposite view, the majority of the legal world, I submit is actually doing so based on an erroneous assumption about what arbitration really is. Now, without further ado, let me put it this way. The scope of consent is what matters tonight. Consent really is the word of the day. And I think using an illustrative example might help. Man meets a woman. Man loves at first sight, bling, bling, bling. But the woman apprehensive, not so sure about what's going on. The man proposes to the woman, and the woman replies as such: I agree to marry you. I will marry you if you go on 100 dates with me. Stop. Rhetorical question for the audience. Did the woman agree to marry the man? My answer is no. I submit, and if you don't take away anything else from tonight's presentation from me, please remember what I'm about to say. I submit that when it comes to love and arbitration, consent should be treated with deference and cautiously too. We should not be dismissive of the issue of consent and say that, oh, they probably wanted to do it, so we'll assume there was consent. No, we should take a more principled approach to looking at whether the parties have agreed, whether in this case a man and a woman, but in the context of our debate, whether the parties to an arbitration agreement, excuse me, has really agreed to arbitration, or whether they limited the scope of their consent such that there might not always be jurisdiction on the part of the tribunal. In this case, the woman limited the scope of her consent by saying, I consent to the marriage if and only if you go on 100 days with me. So I submit until and unless that happens, that consent is not going to be effective in terms of giving the power of jurisdiction to a tribunal. Now, I think intuitively we understand that, hey, if there was a condition, if it wasn't a straight yes, there wasn't any consent. But I think we're going to have to look more deeply than that, going into kind of legal analysis. I submit that limiting the scope of consent and thereby possibly limiting the tribunal's jurisdiction is something that we're all familiar with if you're in the arbitration world. Here is a very run-of-the-mill clause that you'll see up on the screen. It says any dispute arising out of or in connection with this contract shall be referred to arbitration. Now, while not in the form of a condition, I submit that effectively what you're reading here is that the parties have agreed to arbitration if the dispute that they're fighting about arises out of or in connection with the contract. It is essentially or effectively a condition that does limit the scope of the parties' consent. And so if, for example, the parties get into a fistfight unrelated to the contract, although there technically is an agreement to arbitrate, the agreement that they entered into, because there was a condition that the dispute must arise out of the contract, that agreement will not be effective in terms of giving the power to settle the dispute, the jurisdiction, to a tribunal. That is the heart of my submission today. And kind of looking more into why this is legally the sound way to look at this question, the topic of today's debate, I submit that, well, we're simply engaging in an exercise of contractual interpretation. At the end of the day, that's all it is. And the first rule in contractual interpretation, of course, is that we're going to try to divine the party's intent and to give effect to it. The best evidence of the party's intent, by the way, is the objective manifestation of the party's intent as seen through the agreement itself, not any kind of assumptions or extrinsic evidence or whatnot. We should first and foremost dive into the words that the parties put in paper. And here the words are that the parties shall refer the dispute to arbitration if the parties have first attempted to settle the dispute through mediation. Now, my submission tonight is that the language here is as clear as it needs to be. The parties clearly did not want to arbitrate unless and until they finish with the mediation procedure. And so to say that this condition doesn't go to the tribunal's jurisdiction would be effectively to say that the tribunal can hear a case arising out of a dispute between parties when the parties really didn't agree to arbitrate before the tribunal, at least not until the condition was satisfied. Now, at this point, unless there are any questions from the panel of judges, I think I'd like to address, I think, a weakness perhaps in my argument. Something that I do concede is when it comes to conditions that relate to time, oftentimes I think it appears that the parties didn't place too much emphasis on whether the condition is satisfied. And I think that's because when it comes to time conditions, such as 2 weeks must first pass, then the condition is obviously going to be satisfied. So it really is a question of when the claim should be brought, instead of whether the claim can be brought, whether they agree to arbitrate in the first place. I mean, just another illustrative example is this person who is clearly my biological mother calls out, says, In-hyuk, time to eat, dinner's ready. And I'll say, just a second, mom, right? As we always do. And well, let's just assume that I actually meant just a second. I really intended to save my computer game and go join my family. And I think in situations like this, it does appear that I really agreed to go to dinner and join the family. And the few seconds passing that really was immaterial. But I think looking at this example, it becomes a little bit more, I think, obvious that when it comes to multi-tier arbitration clauses, for example, going one slide back, clauses like this, clauses that require you to go to a different forum to mediate first. Now, this is something that the parties actually cared about. The parties didn't want to go to arbitration, want to go to dinner before they finished the game. The game is important. And I think we see this from some court decisions. And I quote here, I have a quote from the Republic of Sierra Leone versus SL Mining Limited, a very recent case from the England and Wales High Court, one of the few decisions that have come out recently, such as, well, I'll get into more of that later, that have ultimately held that a time condition that was the condition in this case, went to the issue of admissibility. The quote I have here is the court's rationale. The court said, the issue here is not whether there is another forum rather than arbitration in which the claim should be decided, but whether the claim has been presented too early. And because it was presented too early in this case, the court said, oh, we'll wait until the condition is satisfied, but eventually we'll take the case because we do have jurisdiction because there wasn't agreement to arbitrate. And I think what's really evident from this rationale is that if it is about another forum, like mediation, and I keep going back to that example, the parties should be really careful about arguing that the parties didn't care about the mediation part of their agreement because the other party might have really cared. And I think that's the objective manifestation of such clauses. And just as a side mention, this authority I have before you today has been cited with approval by the Singapore Court of Appeals recently, and is cited with approval also by Professors Bourne and Professor Paulson. They call this the tribunal versus forum test, a test to determine what the parties intended. And they say if it was presented too early, if it's a time bar claim, okay, maybe the intent is not so clear. But I think the subtext here is that at the very least, when it comes to multi-tier arbitration clauses, the party's intent is clear when you look at the language. And so I think at this point, the question does arise. I mentioned earlier at the start of my speech for the motion that the majority of the legal world actually does not take the same view as I do. They would say that this is a trivial issue that goes to admissibility. It's not about whether the parties limited the scope of their agreement. Well, the answer, I think, to why a lot of jurists have gone this way, I think it's because they're making an erroneous assumption. I think we see that clearly here because Professor Bourne, who I'm quoting from again, his commentaries, that he doesn't hide the fact that he's making a bunch of presumptions and assumptions. I'll read a few excerpts from his commentaries. He says, the better approach is to presume that pre-arbitration procedural requirements, i.e. conditions, are not jurisdictional. He says parties can be assumed to desire a single and centralized forum instead of saying that this is a matter of jurisdiction and allowing the possibility of appeals to a national court. He says parties should be regarded as having presumptively intended for a single neutral arbitral forum or tribunal to resolve questions or issues. Now, I think I see a pattern here because I listed a bunch of authorities underneath this slide. And these are some authorities I want the audience members to really take a good look at least the names of these cases, just in case Ms. Joan Lim Casanova will cite to them again later tonight. These are all court cases that I've cited to this very passage from Professor Bourne as rationale to say that this is an issue of admissibility. So in essence, all of these cases, including Professor Bourne and his commentaries, they relied on the rationale that the parties want efficiency and finality. They're presuming that the parties want a fast resolution of the dispute, no room for appeals, final decision. And they're assuming it so much so that I submit the objective intent of the parties as seen through the arbitration agreement itself is being ignored almost, and in many cases, unfortunately. My submission is that this is a big problem. First of all, as a factual matter, not all parties desire efficiency and finality above all else. Obviously, some parties choose to allow, I think, substantive appeals in some jurisdictions that allow it. But I mean, just going back to something we've seen, mediation clauses. Parties are willing to spend the time to mediate just for a chance at a more amicable resolution to their dispute. The parties are willing to go through procedural hoops, even if it increases cost and time, if it means a better outcome. And I still disagree with the view that efficiency and finality is the end all and be all as a factual matter, but I disagree also in principle. And at this point, I like to ask for the help of Mr. Obi-Wan Kenobi to make a point. I see that I have about 4 minutes left, so if you'll indulge me, esteemed members of the panel and members of the audience. What we see here is the story of Anakin Skywalker. He is the chosen one. He was meant to destroy the Sith, the evil order of power-hungry beings, and bring balance to the world, but he became one of them, power-hungry himself, driven mad by vengeance. And I bring up this a bit of a favorite scene of mine because I am trying to make a point. The way I understand the genesis of arbitration is that parties, commercial parties, sought to seek a different dispute resolution mechanism as compared to litigation. The parties felt kind of caged by how inflexible litigation could be, all the court's requirements and such. And so they wanted to create a dispute resolution mechanism where the parties could make a procedure that was catered to their needs. And I submit that that is why party autonomy is the most important thing when it comes to arbitration. And going back to my explanation of what's been going on in the legal world, how courts have been making assumptions that the parties want finality and efficiency. And so they're making this assumption that the parties probably didn't want the possibility that parties will challenge a tribunal's decision about conditions, which would be possible if it's regarded as an issue of jurisdiction. So the courts are assuming if we say this is an issue of admissibility, which they probably wanted this because, well, that would be the final and efficient thing to do, we don't have to go through all the delays that might be caused. And in doing so, I submit what is going on is party autonomy is being eroded and efficiency and finality is being put up in party autonomy's rightful place. And for those who would suggest that this might not be a big deal, I submit that, small erosions to important principles is always just historically what gets us into trouble in the long run. I mean, just take an example. Yes, Mr. Lim.
Mr. Huang, I think you're into your very last minute and counting down the seconds. So let me ask you this question before you close, which would be, in your argument then, if the parties have agreed to mediate before they can go on to arbitration, if there is no mediation that takes place, or assume that there's a dispute as to whether, in fact, the mediation obligation had been met, does that mean that the parties are then free to go to court instead and have the matter decided in court?
Thank you, Mr. Lim. I think in that case, it would obviously depend on the context of the arbitration agreement, but I think that might be the natural result of my submission, which is that the tribunal would not have jurisdiction over the matter. The parties wanted to mediate first before arbitrating, and if that submission is to be accepted, then the parties should not be able to fight about the mediation part of their dispute before an arbitral panel because they really did not want that result. And I think that concludes my argument. And so I will give the floor to my learned colleague, Ms. Joan Casanova. Thank you.
Thank you very much, Mr. Huang. Well, we'll now hear from Ms. Casanova. And we'll see whether Ms. Casanova can defend arbitration from those who are defeated so easily.
Thank you. Well, for the opposition, we believe that contractual preconditions to arbitration should not be regarded as impediments to the tribunal's jurisdiction. Instead, they raise issues of admissibility, as my learned friend preempted what my case would be. So when I first saw this issue, I was like, jurisdiction or admissibility is so technical. Is the distinction really all that important? Well, yes, because if the question is one of jurisdiction, it's subject to review by national courts, which may reverse the decision of the tribunal. For example, in the English Arbitration Act is provided for in Section 67. There's the International Arbitration Act in Singapore and Article 34 of the Model Law, just to name a few. On the other hand, if the issue is one of admissibility, then there's absolutely no basis to challenge the award. My little friend gave an example of what's the difference between jurisdiction and admissibility. So let me delve a bit deeper into that, because I think it's important to appreciate the distinction, because this is the key area where both sides are cross swords. Many judges and academic writers, they've proffered tests and or explanation to try to differentiate between jurisdiction and admissibility. For example, they say jurisdiction refers to the power of the tribunal to hear a case, while admissibility refers to whether it is appropriate for a tribunal to hear it. The opposition likes this simple test. Is the objecting party taking aim at the tribunal or at the claim? If the objection is aimed at the tribunal, i.e. that this claim should not be arbitrated or adjudicated by the tribunal, but rather should be raised in some other forum instead, then the objection is jurisdictional. On the other hand, if the objection is aimed at the claim, that the claim is stale because it is time barred, or the claimant is barred from bringing the claim because of res judicata estoppel, the objection is one of admissibility. So now let's apply this test to the issue at hand, non-compliance with preconditions to arbitration. Is this objection aimed at the tribunal or at the claim? The opposition say, in essence, is this objection really saying this claim should not be heard at all, or not yet until the preconditions are met? This objection is not aimed at the tribunal. It's not saying that the dispute ought to be resolved in another forum, like in courts, as Mr. Lim question alluded to in the last minute of my learned friend's speech. It does not relate at all to the role or powers of the tribunal. Rather, the objection is taking aim at the claim that it was brought prematurely. The tribunal has the jurisdiction to hear it, but should decline to hear it on the ground that the preconditions to the arbitration were not met. So the opposition is not saying that the agreement to mediate is trivial, as my learned friend alluded to. Not at all. Rather, we're saying that there is such an agreement, but it goes to admissibility, and the tribunal can decide that, well, since you brought it prematurely, I'm declining to hear the rest of it. Next, we examine the arguments for the opposition's case that non-compliance with such preconditions raise the issue of admissibility rather than jurisdiction. When parties come together to do a deal, I would like to believe the last thing on their mind is what happens when good deals go bad. When they finally do get to the part on the dispute resolution clause, and a lot of times it's likely because of as an afterthought or after a lot of harassment from my transactional colleagues to say, can we please run this clause past our litigation or dispute resolution colleagues? And they come knocking at your doors at 11 p.m. say, please get back to us in the next 20 minutes. So most of the time in cross-border deals, the parties agree to arbitrate. They intend that an arbitral tribunal would settle all disputes arising from and in connection with the agreement. Presumably, this would also include disputes arising from the pre-arbitration procedural requirements. Such pre-arbitral conditions often include, in addition to mediation, there's the cooling off period, negotiation, and oftentimes in for matters involving parties in Asia, it is very common to see such a multi-tiered dispute resolution clause, which provides that any dispute would be escalated up the various hierarchies of the respective parties, with representatives of increasing seniority to meet to attempt resolution in good faith. In FIDIC-style construction contracts, the dispute resolution clause will be even more structured and exhaustive. Just to give you an example, in the pre-1999 FIDIC documents, the rate book requires that all disputes be referred to in writing to an engineer for his determination. The engineer is thereafter, within 84 days, obliged to issue a decision in respect of the dispute. If a party is dissatisfied with the decision, it has a period of 17 days from the date of receipt of the engineer's decision to notify the other party that it objects and intends to commence arbitration. Post-1999, FIDIC introduced the Dispute Adjudication Board, the DAB, to replace the engineer's decision that I talked about earlier. And clause 20.4 of the FIDIC 1999 rate book requires that all disputes be referred to the Dispute Adjudication Board to make a determination. The parties have then 28 days thereafter to give notice of dissatisfaction. And this notice is a prerequisite to commencing arbitration, since the DAB's decision would be final and binding if no such notice is given within the stipulated 28 days. So as you can see from the above examples, certain multi-tiered clauses, such as the FIDIC ones, provide clear and methodical steps to be followed prior to commencing arbitration. But for other clauses and other agreements, this could be much less clear, and issues of interpretation would then tend to arise. For example, when parties are expected to enter into good faith settlement negotiations. What constitute good faith negotiations? When would it be considered as exhausted such that arbitration may be triggered? And such issues of interpretation are capable of resolution by the arbitrators, and indeed should be submitted to the arbitrators for determination. When agreeing to the dispute resolution clause, the parties are presumed to intend that a single neutral arbitral tribunal would resolve all questions regarding the procedural requirements and conduct of the parties' dispute resolution mechanism. Earlier, my learned friend brought up this interesting picture of a man proposing to a lady, and the lady says, "I will marry you if you will go on 100 dates with me." And his question posed was, did the lady agree to marry him? My learned friend said no. Well, as a woman, I will say this: a woman means exactly what she says. I know there's various jokes online about if a woman says, "I'm fine," she's not fine, you better be careful. That's wrong. If she says she's fine, she's fine. If she's not fine, she's going to raise the issue with you again later. And she will raise the issue with you again later. If she doesn't, and you still think that something is not right, then raise the issue and talk about it like adults. So going back to the example given by my learned friend, "I will marry you if you go on 100 dates with me." I understand that to be this: if the guy survives 100 dates with me, then yes, like my husband did, I would marry him. Now let's move on to the scenario where it's about two businessmen talking about a deal. And the two businessmen agreed, say, let's have mediation. And if no mediation in 30 days, we agree to arbitrate. Party A then say there's a dispute. Party A writes to Party B and say, let's mediate. Party B refuses to entertain the request, willfully refuses to entertain the request. In that case, then mediation would never take place. In that case, does it mean that the arbitration clause can never be triggered? It can't be right, because going back to my learned friend's point about how parties are not just concerned about finality and efficiency, they're also concerned about the very essence of the agreement, that they agreed to mediate and then arbitrate. But what if one side, like in this case, Party B, just willfully refuses to mediate? Does that mean that Party A needs to bring this case in court? That will be against what they had agreed to in the first place. In a House of Lords decision in the Fiona Trust case, Lord Hoffman said arbitration is consensual. Businessmen in particular are assumed to have entered into agreements to achieve some rational commercial purpose, and an understanding of this purpose will influence the way in which one interprets their language. The parties have entered into a relationship, an agreement, or what is alleged to be an agreement, or what appears on its face to be an agreement, which may give rise to disputes. They want those disputes decided by a tribunal which they have chosen, commonly on the grounds of such matters such as its neutrality, expertise, and privacy, the availability of legal services at the seat of arbitration, and the unobtrusive efficiency of its supervisory law. Particularly in the case of international contracts, they want a quick and efficient adjudication and do not want to take the risks of delay and, in too many cases, partiality in proceedings before a national jurisdiction. So if you agree with us, the opposition, this means that the arbitration offers parties with a one-stop shop to resolve all their disputes, both procedural and substantive ones. The arbitral tribunal decides, issues an award, and thereafter parties move on with their enforcement, move on with their lives. But if you are with the proposition, with my learned friend, what may happen is this. Parties go for arbitration. Respondent objects to the jurisdiction on the ground that the preconditions are not satisfied. Tribunal dismisses the respondent's objection to jurisdiction by way of a preliminary ruling, and tribunal finds that it has jurisdiction over the dispute. So this satisfied with the decision, the respondent brings the action to a national court for a declaration that the tribunal does not have jurisdiction to determine the dispute. Even assuming that the national court agrees with the proposition and decides to set aside the tribunal's ruling on jurisdiction, the claimant will then seek to strictly comply with the preconditions and then appoint a new tribunal. In other words, we are back to where we began, back to square one. It's a huge waste of time, effort, and money. The propositions may say, wait, hang on a minute, even if the issue of preconditions go to admissibility rather than jurisdiction, the tribunal could still determine that a premature claim is not admissible. In that case, the parties may be required to appoint a new tribunal after properly complying with the escalation requirements in the dispute resolution clause. That's correct, but there's one key difference, and that's the effect of finality. Decisions on the tribunal's jurisdiction can be challenged, but decisions as to admissibility cannot be reviewed. The difference lies in not having this additional step of referring the issue regarding the tribunal's jurisdiction to national courts for determination. This means there's no need to spend more money to appoint local lawyers to bring the action in the national court, no need to spend time for the national court to reach a decision if you don't know which jurisdiction you may be in. Some may have a longer lag time compared to others. No need to spend time for national court to reach a decision before appointing a new tribunal. Finally, I said that I will usually not use this argument in the debate, but I thought it would be remiss of me not to do this. The weight of authorities do lean heavily in support of the opposition. So I do think I have the easier case here. The opposition's case is built on the shoulders of academic giants such as Professor Gary Bond, Professor Paulson, and Professor Alex Mills. Professor Bond said that in interpreting the parties' arbitration tribunal, the better approach is to presume, absent contrary evidence, the pre-arbitration procedure requirements are not jurisdictional. In most legal systems, these requirements would be both capable of resolution by the arbitrator and be required to be submitted to the arbitrators, as opposed to a national court for their determination. Professor Paulson said that to understand whether a challenge pertains to jurisdiction or admissibility, one should imagine that it succeeds. If the reason for such an outcome would be that the claim could not be brought to the particular forum seized, the issue is ordinarily one of jurisdiction and subject to further recourse. If the reason would be that the claim should not be heard at all, or at least not yet, then that's ordinarily one of admissibility, and the tribunal's decision is final. Once it is established that the parties have consented to the jurisdiction of a particular tribunal, there's a powerful policy reason, given the multiplicity of fora which might otherwise come into play internationally with hugely different practical outcomes, to recognize its authority to dispose conclusively of other threshold issues. Those are matters of admissibility and allege impediments to consideration of the merits of the dispute, which do not put into question the investiture of the tribunal as such. And it's not just these academic writings. The opposition's case is also supported by important decisions in other jurisdictions, as my learned friend pointed out, in UK, US, Singapore, and Hong Kong. There's the case that my learned friend pointed out, the Republic of Sierra Leone, where the English High Court declined to set aside an award, despite the fact that the defendant had allegedly failed to comply with certain preconditions to arbitration. The English High Court held that the alleged non-compliance was a question of admissibility of the claim before the tribunal and not of jurisdiction. Whether the parties had complied with the pre-arbitration procedures was therefore subject to the final decision of the tribunal and not the question of jurisdiction, which can be reviewed by the English court under the English Arbitration Act. In considering whether preconditions to arbitration is a question of admissibility or jurisdiction, the English High Court there found that the views of leading academic writers, after careful analysis by them, are all one way. These are matters of admissibility rather than jurisdiction. I hear my learned friends saying that, look, you can point to as many cases as you want. There's always cases pointing the other way, like the Singapore Court of Appeal case in International Research Corp and Lufthansa, which appears to suggest that the issues of preconditions go towards jurisdiction rather than admissibility. And in Emirates Trading and English and another Hong Kong case, the English and Hong Kong courts regarded the preconditions to arbitrate as a matter of jurisdiction. I looked at those cases. In each of those cases cited above, the question of whether preconditions go towards jurisdiction or admissibility was not specifically argued. So I would say that those decisions are of limited significance to this debate, which is brought into the spotlight. In fact, there's two very recent cases, one in Hong Kong High Court, a 2021 case, where the Hong Kong High Court says that the academic works and international authorities demonstrate that the distinction between jurisdiction and admissibility is not one only to be drawn on the specific wording of the written law of a particular jurisdiction, but is a concept rooted in the nature of arbitration itself. They also point out policy reasons that justify different legal treatment of jurisdictional challenges and admissibility challenges. The approach espoused in the international materials referred to seems to the Hong Kong High Court to be entirely consistent with the policy in Hong Kong law, which respects the parties' autonomy in choosing arbitration as the means to resolve their disputes. And just last month, there is an English High Court case, NWA and NVF. Just released on the 8th of October. In that case, the English High Court examined this specific issue, might as well participate in this debate. There, the arbitrator issued a partial award, saying that the claimants were arguably not in breach of the mediation clause because they had sent a covering letter accompanying their request for arbitration, saying that they are proposing to stay the arbitration in favor of mediation, and the claimants had made efforts to seek settlement by mediation. The claimants applied to the English High Court to set aside the partial award, and the central question was the motion for this debate. And there, the English High Court held that non-compliance with the preconditions go towards admissibility rather than jurisdiction for the following reasons. One, parties as rational businessmen consensually agreed and intended that any dispute arising out of or in connection with their agreement should be referred to arbitration. Two, it should be resolved swiftly by arbitration. If no settlement within 30 days of mediation, go to arbitration and use the expedited process therein. The claimant argued that if the claim should be rejected as outside the jurisdiction of the tribunals, but the consequence of this argument, as I mentioned above, is that if one party willfully refuses to mediate, then the tribunal would never gain jurisdiction over the dispute, despite the parties clearly agreeing to arbitrate. So if you are for the opposition, it means that you are choosing to support a one-stop shop for disputes to be resolved through arbitration without unnecessary delay and expense, and uphold the principle of certainty that parties to arbitration agreement hold dearly. Thank you.
Ms. Lim, I think you may have maybe a few seconds before your minute runs out. Let me ask you this: is your argument that a precondition to arbitration can never be a question of jurisdiction?
I think in certain local systems, there may be certain contrary legislation. So if that's the case, then it could go towards the issues of jurisdiction. But overwhelmingly, I find that in the authorities that I've seen, there's no such local legislation which determines that the issue must go towards jurisdiction. So if the other countries or states don't have such legislation, I hope that they'll agree with the opposition, never put in place such legislation that makes the issue of precondition to go towards the issue of jurisdiction rather than admissibility.
Thank you very much, Ms. Lim. Well, Mr. Huang, you've got 5 minutes to redeem yourself against the weight of authority.
Yes. And I think I'll start. I have just 3 points of rebuttal. I'll start with the question that was addressed to Ms. Jo Lim Casanova just now. And she, I think, gives me some concern. Her answer does, because she mentioned that unless there's some special local legislation, I think it's hard to imagine a situation where an arbitration agreement and the condition, the failure, that doesn't go to the issue of jurisdiction. Oh, no, I'm sorry. I think she said that it's hard for her to imagine a situation where that does go to the issue of jurisdiction. And I think that kind of denies a common ground I thought we had, which is that at the end of the day, it's about looking into the party's intent. And so I think that approach, we should approach that with caution. On the second point in rebuttal that I want to make is, I think Ms. Jo Lim Casanova presented a really reasonable case, a practical case that talked a lot about the delays that might happen, the costs, the never-ending cycle that might happen. And I think because I'm a relatively inexperienced lawyer, I have the luxury of kind of bringing a fresh perspective and not really being mired down by what's practical. And that perspective is this: delays and costs, that's a great evil. But I submit that there is a greater evil, which is that a party that has not consented to arbitration is bound by a final decision by a tribunal that they had no intention of coming before, and being rendered a final award against them. And it's hard to challenge that, obviously, because as we have been discussing, there's no challenging, unless in very corner jurisdictions, the merits of an award. You can only challenge an issue that goes to jurisdiction. And I think that connects to my third point in rebuttal. Ms. Jo Lim Casanova said that if a condition has not been met, an arbitral tribunal will do the reasonable thing. They're smart. They will decline to hear the case because the condition has not been met. But my question is, are they free to hear the case nonetheless? And the frightening answer is yes. They can decide to take on the case because it will earn them revenue, I say. And well, there's no challenging that decision because it's an issue of admissibility. Like she said, it's a final decision that cannot be reviewed by a national court. And I think that frightens me a little. And I'm kind of willing to be free from that fear, even if it costs some parties money. And I think, practically speaking, it'll have to mean that parties will have to be smarter about drafting. For example, if one party willingly refuses to mediate, maybe provide a kind of a third way of saying, hey, if someone willingly does this and there's a dispute about whether they're willingly doing this, we'll settle that, very limited issue before a, in an expedited procedure or some sorts. I don't know. The possibilities are out there, but I mean, we're going to have to find a solution to this instead of simply saying, oh, this is going to cost money. Let's just kind of sweep it all under the rug. And I have this concern because I know that power tends to corrupt. I know I'm being a little dramatic here, but I mean, we have to be a little dramatic if we're going to see past these kind of practical realities and kind of look at what's going wrong in this picture. I mean, if there's just one case where an arbitral panel decides to hear a case that they shouldn't hear, I think preventing that one egregious wrong is worth the cost that a lot of parties may have to additionally incur, especially because those additional costs can be prevented by smart drafting, which is on our part. That's, with that, I will end my rebuttal. Thank you.
Thank you very much, Mr. Huang. Well, Ms. Lim, it's back to you
Stephen,
to defend.
sorry,
Oh,
Stephen, I just
yes.
have one question, perhaps coming slightly to the defense of Mr. Lim, the arbitrator. So, Mr. Huang, is it not possible that even if an issue is decided as a question of admissibility, the court still has the power of review over an award on the basis that there was no consent and therefore no arbitration agreement? Is that not so? In which case there still lies some remedy to the parties aggrieved by this ruling.
I think I see your point, Judge, and I think it's a great point. It does undercut a lot of what I've put forward tonight, but I think it has a different effect too. If the court will ultimately have review powers over an arbitral panel's decision of admissibility, then that means, courts will ultimately be able to review this decision. And so why not let the parties bring that decision to the courts early on, before the entire 2 years of arbitral process? And I think if we look at it in this perspective, I think it makes a little bit more sense to treat this as an issue of jurisdiction, ma'am.
Thank you.
Oh,
Ms. Casanova. Sorry,
yes.
Stephen, go ahead.
Well, I was going to invite Ms. Casanova to defend now not just the integrity of arbitration, but the honor of arbitrators.
Yes, so my learned friend said that arbitrators may find creative way to nonetheless hear the case, even if the preconditions are not met, because that's where they earn their revenue. Because I would think that the audience are all young SIAC members, right? So I hope they're not too jaded to think that of arbitrators. If what my learned friend fears come true, then the arbitrator is not doing himself or herself any justice. The circle is big, but really also not that big. So if the arbitrator is bending backwards to nevertheless hear the case and find that he or she should continue to hear the case even if preconditions are not met, then word gets around and the arbitrator won't get appointed anymore. So there is a check and balance within the arbitration realm, even without the intervention of the national courts. And I don't hear a response from my learned friend as to what happens if one party simply refuses to participate in the mediation or the preconditions. Does it mean that the tribunal can never be appointed to hear the arbitration? Because in that case, it will, my learned friend is saying that it will go to a national court. And if that's the case, then you're not really supporting the agreement of the parties, which you had argued trumped the effect of efficiency and finality. That's all.
Shanine?
Thanks. Thank you both. Very convincing arguments on both sides. And that's really, that's the fun of being a lawyer, isn't it? Today you argue one proposition in one way, and the next day the other. And of course, it depends on the kind of clause, on the facts of the case, the lawyer's famous answer of it depends. I think in this case, finally, it boils down to the fact that multi-tier clauses are enforceable, that arbitration cannot or should not proceed unless they have been complied with. If this preclusion is treated as an issue of admissibility, it is not open to judicial review per se, but there is always the possibility of challenging an award on the grounds that there was no consent or the arbitration agreement did not exist. If the preclusion goes to jurisdiction, of course, the issue is open to examination by a court. But really, whichever way one looks at it, the arbitration cannot proceed. But to take the point which Joan brought up, that there may be reasons why the tiered provisions could not have been complied with. Joan's example of willful refusal to comply, or even where there may have been substantial compliance with the clause, particularly where it is not clear or set out in detail. For instance, the general good faith attempt to resolve the disputes, in which case the arbitration itself would be defeated by virtue thereof. So the practical lesson, I think I think all litigation teams advise their corporate teams would be to have a clear, specific clause, for instance, like the Lufthansa clause which Joan also referred to, failing which, and I quote SIAC's erstwhile president, Gary Bourne, who has been quoted by every participant in this essay, that otherwise the tiers just become a dismal swamp, not promoting efficiency, which is, the flag bearer of international arbitration. But just thank you, brilliant arguments to both. I really enjoyed hearing you. Thanks. Kate, over to you.
Well, let me add my thanks again to In-Hyuk and Joan. Congratulations again for making it thus far. I think you've proven to us two again and to the audience that you deserve to be here and engage our attention. I want to say one thing, and I don't know whether Kit can answer this question, but I was a bit surprised when I got the shortlisted essays that I think we had twice as many for the proposition than against. And I was quite surprised because I thought the for would have the easier job and the against the harder job. But maybe this is, the prevailing jurisprudence on this is really unpopular, and maybe the next generation is going to tell us that we were wrong and that it should be a jurisdictional issue.
Great, thank you very much. What is left for me really is just to say congratulations again, In-Hyuk and Joanne, very well done. And a special thanks to the judges of the writing competition, Shanine and Stephen. Thank you for joining us today. And also a special thanks to Freshfields as the prize sponsor, to the supporting organizations, to the Young SIAC Publications Subcommittee, and to SIAC, especially Annaline and Lynn, for helping organize this event. And that's all from us. Have a good rest of your day.
Thank you.
Goodbye.